I agree. All right. So let's keep going. Let's keep going.
Right.
If you don't know what that means, you will. Next thing, legal basis. You have to have a legal basis in order to well, you don't have to have a legal basis. You can sue for anything.
Sure.
But when you get in front of before you get in front of a judge, they're gonna say, what's the legal basis you're gonna sue on? What?
Let me stop right there. When he says legal basis, he means cause of action. Just to correct what he's saying, that because people, most people don't know. They just say legal basis.
That's right.
He's talking about cause of action, which is the reason why we in here.
Yeah, and it's best to just break it down like that, just for those. Many people may know, but maybe one or two who may not know, and what you just said would help.
Right.
What? Invasion of privacy? No, your privacy wasn't invaded.
Nope.
You use my image illegally. That's a policy.
Right.
It's not. That's not a law. What is the law that was broken?
Let me stop right there again.
Yeah, he's tripping.
Again, we just showed that there is case law to support. Now I'm gonna go back to it. Because repetition is.
Didn't you find the statute last time? But that's in the first video. The statute that supports this case law.
Right here. The courts in North Carolina, and let me highlight this first part. It says in Renwick, the majority listed 4 types of privacy torts. Now, privacy torts are violation of privacy, y'all. Privacy torts. And
it's a cause of action. It's a private remedy.
Yes.
Torts is private. Status law is private. Things like that are private. Status, that's private. Constitution, tax law, administrative law, that's public law. So he's kind of missing public law and privacy. He doesn't understand these key words like privacy tort. Right. That's a privacy claim, cause of action. And what he's talking about, your legal basis. That's your AKA legal basis, privacy tort.
Yep.
But go ahead. My bad.
All right. Oh, no. You're fine. And the privacy tort will be appropriation of Jessica's name and likeness for Kevin Samuel's advantage. That would be the proper one. Now, in the first video that we done on this, we covered all 4 of them. So we're not covering all 4, y'all. We just dealing with the first one. We already know that this is the only privacy tort that makes sense, that has any type of merit where she does have a case. So again, like we stated earlier in this video, if there's a tort that exists on the books, that means it's a law there that supports it. So this is law that we're dealing with. All right. I wanted to make that clear. You know what I'm saying, Rodney?
Absolutely.
All right. So let's keep going.
And people break policies all the time. People don't go to jail for breaking policies. They go to jail for breaking
Well, and the thing is, but here's where it gets tricky, because there can be a case made for modern law enforcement.
I just had to stop right here real quick, because matter of fact, let me go back a little bit. I want to make sure I heard what I think I heard, because I don't want to misquote. Let me just play it right here real quick.
Law. What is the law that was broken? And
people break policies all the time. People don't go to jail for breaking policies. They go to jail.
Okay. I did hear what I thought I heard. Basically, he's saying people go to jail for breaking laws, not policies, right? Well, guess what? A privacy tort is a part of the law of that particular state. Now, all laws that get broken are not jailable. So some laws can be broken, but it doesn't mean that you're going to jail. So I did want to make that point.
That's the difference in criminal law and civil law.
Right.
Civil law, typically you don't go to jail for unless there's a jailable section attached to the civil law. Criminal law, it's a possibility for you to go to the penalty box. Go ahead.
Well, and the thing is, but here's where it gets tricky, because there can be a case made for modern law enforcement enforcing policies versus law. There's an entire sector on YouTube called First Amendment audits, where they go around and go like filming where they'll go around and like film in a public federal space.
Yeah.
And watch federal employees lose their mind, call the police to try to get them trespassed. Like filming in a post office is legal.
Wow.
It's legal.
Okay.
It's even posted on the postmaster's rules on the wall. It's called Article 7. But yet, go to your local post office and pull out your camera and start filming. And I can almost guarantee 99 out of 100 of you that either the woman behind the counter or somebody will tell you that you need my permission to record me, and that's against the law. No.
I want to stop right there real quick. He is 100% correct that going inside the post office and places like that, that is public property in a sense, so you can record. That is very true. And then I also agree with him that in most cases you will get an employee that try to tell you that you can't record, but that's right. That is public. All right.
It's not against the law. Well, you see that says no cell phone, this and that. That's a policy. A policy means something that you as an employer or somebody that works there. We don't have to deal with policy. We deal with law.
That's right.
You go into the post office and film, and there's hundreds of videos of.
Let me stop right there. Now, again, we're dealing with law too. We're dealing with law. So I got to go back to this. Let me go back to this again, because repetition is how we learn as humans. So I want to hit this home again. We're dealing with law, case law, right? Judge-made law, precedent, common law. It has many different terms, right? That the court says, right, that you do have what is called appropriation of a plaintiff's name, which would be Jessica's name, or likeness for a defendant's, which would be Kevin Samuels' advantage. That does exist. So in our opinion, here at the Power of Offense, Jessica does have a legitimate cause of action, right? Now, the challenge will be, right here, it says our Supreme Court has held that the right of privacy exists in North Carolina and has recognized the first type of privacy tort being invasion of privacy by the unauthorized appropriation of a plaintiff's, which would be Jessica's, photographic likeness for defendant's, Kevin Samuels' advantage as part of an advertisement or commercial enterprise. Now, the only reason I'm saying this is a challenge, right? It's because Jessica's attorney would have to prove that YouTube, right, which is a social media platform, is also a commercial enterprise. Now, I believe it can be done. I do. I don't even believe it's difficult to prove it. And the reason why I'm saying that is because YouTube generates revenue. You know, it's a little different than like a Facebook platform where you have your Facebook page up there, but they're not paying you for people viewing your Facebook page. See, YouTube actually pays us content creators for views. So that is a commercial enterprise. I just wanted to point that out. You have any comments to make on that, Rodney?
No, I totally agree.
Okay.
People calling the police, 911, because somebody pulled out their phone and started recording. Now, damn the 35 cameras that are around there. Forget everybody that's doing this. The thing is, this is freedom of speech. This is free speech, and it's freedom of the press. There is no expectation of privacy in public, especially in certain places. Now, if it's a personal business or something else like that, that's different. But in public,
say your house.
But that's your private space. If you want privacy, go home and close the blinds.
There it is.
All right. So legal basis. So no laws are broken on YouTube. You volunteer to be on any video platform or whatever.
Now let me stop right there. He's right. You do volunteer to participate on a platform like on YouTube. So these women, right now, specifically, we're talking about Jessica, aka Miss Average at Best. She did choose, right? She did knowingly and willingly participate, right, in Kevin's broadcast. There is some truth to that, right? But again, it still doesn't mean that YouTube cannot be considered to be a commercial enterprise. So possibly a law was broken.
And even though she may have volunteered to be on a show, she may have volunteered to provide personal and private information about herself. She may have volunteered to everything that's Kevin saying, but she did not volunteer. Notice she waived her right for Kevin to profit off her likeness and image.
Right. I agree.
So that's like checkmate. So it depends on how they structure and bring their claim and how they defend it.
Right.
But if it was me, that was the only claim I would bring, so that way that'll take away a chunk of their response. You know what I'm saying? Because you know how they cherry pick and try to choose something to attack, the only thing that they can possibly prevail. Right. So yeah, that's it. So he just a little confused right now, but keep it moving.
Yeah. Yep. Just keep it moving.
It's like going on to the Tonight Show.
Right.
And saying, but here's the other thing.
Stop right there.
This whole thing about
just like going on the Tonight Show. If anyone ever been on the Tonight Show, they would know that there's waivers and signs or compensations, agreements, and everything you sign before you go on the Tonight Show. So he had to provide the waivers, the compensation, everything that he provided for people to come on his talk show. Go ahead.
Good point.